All right. Hello, everyone, and welcome to another episode of GovCon Roundup Live. My name is Carroll Bernard, co-founder and CEO here at Govology.com, and I'm joined by my friend and Govology legal analyst and GovCon expert, Mr. Stephen Koprince. How you doing today, Stephen?
Hey, doing great, Carol. Good to be here with you again for one of our GovCon Roundup Live editions. I'm looking forward to it.
Yeah, we've got a lot to get to today. And this is going to be a special session. Typically, we go for about an hour or so, but today we're going to be doing probably a little bit of overtime. We originally planned this show to really just talk about some of the changes within the WOSB program, but there's been so much that's happened over the last month. We thought, hey, we really need to cover some of these topics. And it's also very timely because some of the things that we're going to be discussing today has a time-bound window where you might want to submit some comments in relation to some of the changes that we're going to be talking about. Let's go ahead and just dive right in, Stephen. So let's first start with the WOSB program. Stephen, could you talk a little bit about the history of the program? How has the program compared to some of the other socioeconomic programs in terms of usage and set aside by government agencies? And then what do you see as some of the past challenges up to maybe the recent times before we get into the changes that are being proposed in the FAR overhaul? What are some of those challenges that you've seen with the program overall?
Yeah, it's a great question, great jumping off point. And those who follow my GovCon Roundup newsletter on LinkedIn know that there have been in the last several months, I've published a number of articles on the Women-Owned Small Business Program, both in terms of some changes and potential changes to the program, but also trying to focus a little bit more on what you mentioned right there, Carol, which is the actual usage of the program and the tools that it provides contracting officers to be able to push business to the prime contracting level as well as the subcontracting level and large primes. But at the prime contract level, the tools of set aside and sole source contracts. So let's step back a little bit. This woman-owned small business program, where does it fit in the broader realm of federal government contracting and specifically the small business preference programs that are established under the SBA, Small Business Administration regulations, and in FAR Part 19. We go back really almost 20 years or so now. It seems like sometimes like it's been longer than that. Sometimes it feels like it's just yesterday when this program, this idea and the reality of a program for women-owned small businesses started to take effect and find its way into the FAR. And the notion, it's a valid notion based on the statistical research that the SBA has done in many industries, is that in many industries in this country, women-owned businesses have historically not done very well. They haven't won what would be considered a fair proportion of the work based on their representation within that field. And so how do we promote women-owned businesses as a federal government entity? And so what was developed was this woman-owned small business program, and it was limited initially in two important ways when it first found its way into the FAR. First, it was limited by NAICS codes. In other words, the woman-owned small business set-asides were only available under certain NAICS codes. That continues today, by the way. That has been a point of common frustration among women-owned small business owners. They'll say, why are our contracts restricted by NAICS codes, whereas contracts for HubZone are not? Contracts for SDVOSB are not. Also true. Why was the contracts for 8A are not restricted by NAICS codes? Why women-owned small business contracts have that restriction? The answer, though, is that it's a constitutional question. In order to draw a gender-based distinction in the law, you have to have darn good reason to do it. That's not what the lawyers would say at the Supreme Court, right, or the judges. But you have to have really good reason. You have to have support for that. You have to have evidence for it. And so SBA's mindset since this program took off was always, we're going to make these set-aside contracts available only in the NAICS codes for which we have gathered enough evidence that we are confident we could survive a legal challenge to draw gender-based lines in the sand. And that actually, I think, as we move forward 20 years, is probably pretty important now when we're seeing these sorts of legal challenges to the program. So limits by NAICS codes, and that's always been a limit. Over the years, those NAICS codes, though, have expanded because SBA didn't just stop with the research it did when that program first went online. It continued doing research. And remember, there are hundreds of NAICS codes on industry after industry and slowly expanding the universe of contracts that are available for women-owned small businesses. But that's one way that program was limited from the get-go. Second way the program was limited from the get-go was that the only tool available to contracting officers to push business to women-owned small businesses was set-aside contracts. There was no opportunity for sole source contracts to WSBs. That changed maybe 9, 10 years ago, there was a statute passed to allow sole sourcing to WSBs, and so that eventually was put into the FAR as well. The sole source component of the program looks pretty identical for HubZone and SDVOSB, Service Disabled Veteran-Owned Small Business, but is not as powerful as you see for the ADA. And then the final challenge that the program had when it started, and I think it proved to be a challenge that we're going to still be talking about today, was that the program wasn't really sure whether we wanted certification of WSBs or self-certification. And so the program initially started with the option for companies to either self-certify that they were WSB with a sort of what I call trust but verify system, where if you self-certified and won a contract, then the government was supposed to check your documents at that point, or you could pay money and get certified by a nonprofit agency that was contracted by the SBA to provide the certifications. It's not surprising that most folks chose not to pay the money and go through that upfront process and self-certified. What happened, though, is that when studies were done on self-certified WSBs, the SBA about 10 years ago did a study and found maybe 35% that had that self-certification didn't actually qualify. The NASA Inspector General took a look at contracts that awarded a sample set of contracts that it had awarded. This was also about 10, 11 years ago, and found that those contracts in which someone had checked the WSB box, about 40% or so of those companies probably weren't eligible either. They had things like the CEO was a woman's husband, was a man that was holding the highest officer position. So what that did is pose a further challenge to the program in that it undermined confidence in the program. The contracting officers were not confident that a self-certified WSB actually met the criteria. And so when you add together the NAICS code limitations, you add together the lack of the sole source component, you add in this lack of confidence in the program, I think those things together really hampered the program moving forward, even though those things have been corrected slowly over time. In 2020, we got formal certification at the prime contracting level. The NAICS codes have expanded. The sole source authority was added. But you have a program that started in not really a great place and is still trying, I think, in some level to emerge from that place. And that's where we find ourselves today.
Yeah, very interesting. I kind of wonder why, I don't know if you have any insight on this, Stephen. Instead of making the program where there's some NAICS codes you can set aside for WOSBs, some they're special for EDWSBs, the economically disadvantaged women-owned small businesses, couldn't the SBA have made it a little bit easier just based upon that disparity that you mentioned? And a lot of this comes around by some of these studies. Wouldn't it have been easier for them to just say, hey, come into the 8A program and make the language of the 8A program a little bit broader to be able to help these WOSBs get into that business development program?
Yeah, that's one strategy that could have been considered for sure. And in fact, contrary to what some folks believe, it's always been possible for women to be admitted to 8A, but women as a class were not presumed socially disadvantaged. Right. And so women had to individually prove that they had experienced bias or discrimination based on their gender and that it had a substantial impact, a real life impact on their education, on their employment, on their business success. And that was a burden that I helped a number of women, including Caucasian women, and I say Caucasian because there was a mindset that Caucasians could never be in the 8A program, but I helped a number of Caucasian women pass that threshold and get into 8A, but it wasn't easy to do, and that could have been an alternate approach. However, and again, I will preface this by saying I am a lawyer by trade. I'm not practicing right now. I was never a constitutional lawyer. I took constitutional law in law school and read the Constitution. That's about it. But as I do understand it, that if the SBA had adopted women as a presumed disadvantaged class under their rules, that might have been ultimately problematic when those court challenges came out. And some of you who are familiar with how this has played out in the last few years may remember this Ultima case in which that presumption of social disadvantage in the 8A program was wiped out entirely. There was just another case in the Department of Transportation's Disadvantaged Business Entity DBE program. Same result. That program did include women as a presumed disadvantaged class, and that presumption was wiped out, all because really goes back to there was not enough foundational evidence to prove that you could draw racial or gender lines in the sand, which is a high burden to meet. It's not illegal necessarily to make laws that have those distinctions, but you have to meet a high burden. And so I think the way the SBA did it with the NAICS codes, which was very frustrating, but I think that now that we're seeing these court challenges, they put that program in a better footing to survive because they have the backup documentation to say, yeah, we've drawn a gender-based line here. We have, but here's why. here's the evidence that supports us doing that. And it meets that threshold in a way that I think 8A never did. For example, 8A had a situation where they would just start listing countries in place and say, if you're from South Korea, you're presumed disadvantaged, but if you're from North Korea, you're not. And I'm like, all right, we don't have a lot of North Koreans running around this country, but I have a hard time believing they're not experiencing the same level of bias that a South Korean would. Just things like that. But yeah, it's a frustrating situation, but I think they foresaw, the founders of this program, that there may be court challenges and did what they could to bolster the case, to keep that program alive. I would venture to guess that is one of the reasons why that program is still on solid footing right now.
Yeah, on the surface, kind of looks like a minority business program, and some states have the minority business programs. If you meet the socially and economically disadvantaged criteria, really anybody could apply for the program.
Yeah, that's it. And so 8A is that way now, and the DOT DBE program is now, where you have to meet certain economic thresholds of net worth and income. You have to fall below those thresholds. And then you just have to prove that you personally have experienced bias or discrimination based on some sort of objective characteristic, which could be your race, could be your gender, could be a disability. There are all sorts of different religion, different factors that may have caused that in your life. You've experienced bias or discrimination that held you back in some way in education, employment, and or business. And so that's where these programs are right now. And that's what has been decided after these court cases, to make sure that we really are using these programs to find folks who have not had a level playing field and get them to a place where they are on a level playing field.
Yeah, very powerful. And I think that when we get towards the third segment of this, we're going to be talking more about the 8A program, and it's still going to have the power that it once had. We'll get to that. But in terms of the recent changes that have happened with regards to WOSBs, and you talked about the three challenges historically been there: limited by NAICS code, set aside contracts, also not as powerful for the sole source advantage that you can get with the 8A program. What changes have you seen most recently? And do you see the changes as positive, more challenging, or maybe just neutral?
Yeah, and let me preface this. I want to talk changes, but I also want to talk some numbers, because I think the numbers are important here in terms of understanding the challenges that this program has. So those of you who are familiar with the SBA's annual goals and their statutory goals for 23% of prime contracting dollars to small businesses, for example, the prime contracting goal for women-owned small business since this program was created has been 5% of prime contracting dollars, which sounds pretty good. And the actual achievement last year was about 4.97%. Really, it's fiscal year 24 now, which is 2 fiscal years ago from the current one, but that's the latest for which we have finalized data from SBA. It was 4.97%, which is awfully close to that goal. Unfortunately, they've only met the 5% goal once out of 20 years, which is not great. But still, that doesn't sound so bad. However, how often are those women-owned small business tools being used, the set-aside and sole source contracts? It's shockingly low. In fiscal year 2024, women-owned small business set-aside contracts only accounted for 0.35% of federal prime contract spending. 0.35% of federal contract spending was spent through women-owned small business set-aside contracts. Women-owned sole source contracts, WSB sole source contracts, 0.02%. 0.02% of prime contracting dollars were awarded through sole source contracts for WOSB. And so what does that tell you? How is the government getting to 4.97%, by the way? How is it getting there? It is getting there primarily not through using the actual tools that exist to push business to WOSBs, but through double counting awards that are made under other vehicles. And so if the government awards a small business set-aside contract and the awardee happens to have self-certified in SAM as a WOSB, then the government counts those dollars toward WOSB 5% goal. If they award an 8A contract and the awardee is WSB, counts toward, and that's how the vast majority of that 5% goal is being met. Now, some might say, who cares how they're getting work to those companies? The issue is, though, that outside the WSB sole source and set aside context, the government is allowed to count dollars awarded to self-certified women-owned small businesses. Remember how I mentioned in 2020 we eliminated self-certification? Sort of. Self-certification was only eliminated for eligibility for WSB set-aside and sole source contracts. However, the government is still allowed to count toward its prime contracting goals self-certified women-owned small businesses who are awarded under other vehicles, like the small business set-aside contracts. And what we know from historical audits that have been done by GAO, NASA, IG, is that a good percent, a large percent, 30 to 40% perhaps, of self-certified WSBs don't actually qualify. And that's, in my view, not even mostly because of fraud, but because they don't understand the rules. They haven't done their due diligence. They don't understand the control requirements, things that are not just the woman's ownership. And so what we've got is a setup in which I would venture to guess that of the 4.97%, some probably more than 1%, maybe 2%, who knows, but some half of that number, a third of that number is going to ineligible companies. That's the problem that we face right now. Is the government's counting a lot of self-certified companies toward its WSB goals. Large primes are also doing it, or other than small primes, because large prime contractors that operate under small business subcontracting plans also can count self-certified WSBs toward their prime contracting goals. So that's where we are now, and that's what the changes that we're seeing is this push away from this vestiges of self-certification. And I think that will be helpful in bringing real clarity to how many of these dollars are going to actual eligible certified women-owned small businesses. So we've seen one recent change and one potential change are big in that area. So the FAR overhaul, we're going to talk about the overhaul of FAR Part 19, the revolutionary FAR overhaul, or RFO as it's called, because everything has an acronym in government contracts. What it did with very little fanfare, and I've got an article I just published a couple days ago on this on my Roundup LinkedIn newsletter, is it eliminated the ability of large primes or other than small primes, it's anyone who's not a small business, operating under subcontracting plans to count self-certified WSBs toward the WSB subcontracting plan goal. And so these prime contractors now can only count moving forward under FAR Part 19 certified woman-owned small businesses toward subcontracting plan goals. And that's a change that was made in the revolutionary FAR overhaul revision of FAR Part 19. It's not yet been confirmed in the SBA's regulations, so there's a little conflict there right now. But the FAR Part 19 now says that only certified woman-owned small businesses can count toward a prime's subcontracting goals. And there's also a piece of legislation that has been passed by the House of Representatives. It's called the WSB Accountability Act of 2025, and it was passed unanimously out of the Small Business Committee in the House, which in today's political climate, anything that's been passed unanimously from a committee, you got, wow, we got members of both parties agreeing on something. It passed, I think it was 25-0 out of the House Small Business Committee, passed the full House on a voice vote, which means that basically nobody stood up and objected and said we need to have a full vote on this, because there's not that kind of anybody who felt strongly enough to do that. And so it's in front of the Senate now. And if that bill goes through, what it would do is it would prevent the government from counting at the prime contract level dollars awarded to self-certified WSBs toward that 5% goal. And so I think that that bill, what it's really designed to do is take away that incentive for contracting officers and agencies to say, we don't need to use the tools that are in the FAR. We don't need to use the WSB set-asides. We don't need to use the WSB sole sources, because we're going to get most of the way, if not all the way, to that 5% just by randomly awarding 8A contracts and small business set-aside contracts, and then just some number of those companies will check the box and say for WSB. And we'll just count all those, and so we don't need to worry about using that tool. And I think that there's some of that going on right now, even if it's at the subconscious level, where that WSB's tools, the set-aside and sole source contracts, are being de-emphasized because the agencies are getting most of the way to 5% by counting self-certified or certified, but mostly self-certified, I imagine, WSBs who are awarded contracts under other vehicles and getting to the 5% that way.
Yeah, a lot of interesting things there, lots to take in. And I know we're probably going to talk some more about this when we get to some of the changes within the revolutionary FAR overhaul, FAR Part 19, because there's been some order of precedence. And we've got a lot to get to. We're going to start to shift it a little bit. But for those of you guys who are with us, please feel free to ask the questions that you've got. But the last thing is for the WOSBs that are listening in today, wondering what the future holds in store for them, what advice would you give them to look forward to? Is there any optimism on these new changes? Really, one of the big things that you hit on is that they're just really both in the subcontracts and in the direct contracts. So you're going to be they're going to count an award to a WSB. They're going to be a certified WSB, which the dismal numbers that you basically just mentioned before, even those could be skewed from people that actually don't meet the certification when the self-certification option is there.
So know that when contracts are awarded by WSB set aside or sole source, those go only to certified companies because that's been required since 2020.
Yeah.
But that counts for 0.37% of prime contracting dollars. So the difference between 4.97 and 0.37, whatever that is, 4.6%, that universe consists of some certified companies and a lot of self-certified companies. And so if I'm a WSB now and I'm self-certified, the answer is clear. Go get your certification, because if you're doing that just at the subcontract level, self-certifying, you're going to need a certification moving forward. If you're a WSB at the prime contract level who's certified, I'm hopeful that if we can get this WSB Accountability Act passed, it will remove that disincentive to use the WSB set aside and sole source tools, because contract officers will no longer be able to rely on getting those self-certified folks who are checking that box when they award a small business set aside or whatever. It's going to be only certified companies. So it should increase, I would hope, the use of those tools as well. It's always worth looking into 8A. You mentioned that earlier, Carroll. 8A just is a more powerful sole source preference by the way that preference is structured. And it's not just that where the program has a sole source preference, it's how that preference is structured. And if you think that, hey, I see a lot more 8A sole source awards than WSB, you're not wrong. I ran the math on the back of the envelope math, and my conclusion on fiscal year 2024 is that 8A sole sources were $115 more through those vehicles than through women-owned small businesses. And that's exactly what the RFO folks did too. They said, let's make sure that these subcontracts are going to companies that we know qualify, that they're not self-certifying under what are complex and sometimes confusing regulations that people can easily get wrong or make false assumptions about. So I'm cautiously optimistic that this program is going in a good direction, but we'll see. It's been a long and winding road for women-owned small businesses in federal contracting, and that absolutely continues right now in 2025.
Yeah. And before we shift to the next segment here, one bit of advice that I would give, we talk about a lot in our trainings here at Govology, and not just me, but other presenters talk about it, is just whether you're a WOSB or you have any of the other small business certifications out there, don't just rely on building your business based upon those certifications. I see a lot of contractors do that. They're like, we're only going to look at WSB set-asides. Work on building your value so that you can be competitive across the board, really, because you're going to see a lot more small business set-asides, and we'll talk about maybe how the FAR overhaul is going to have even more small business set-asides above maybe some of the socioeconomic set-asides. So work to be more competitive just across the board, and not only in the small business environment, but what I love to see is when a lot of those small businesses are out there openly competing head to head in full and open competitions with some of the bigger businesses and winning. And I think that we're going to see in the future, because of what AI is enabling us to do, which we could never do before as small businesses in terms of just capacity and affordability, it's really going to be a new age for small business. And I believe personally, and this is just my opinion, but it's going to better help small businesses kind of level the playing field for themselves, rather than trying to rely on the government to create rules that is designed to help some of these various socioeconomic groups, but that it's never really quite level. But we'll get to more of that here in a second. That was a great discussion. And I know we're going to talk some more about the WOSB as it relates to some of the FAR overhaul stuff. Let's get to the threshold changes. By the way, Happy New Year for federal fiscal year 2026. And as of October 1st was the new federal fiscal year. And we had some changes to the procurement thresholds. Can you talk about those changes? And that's not necessarily related to FAR overhaul. That's just part of their adjustment that happens every 5 years, correct?
Yeah, that's it. And yes, happy fiscal new year, as seems to be often the case. We're celebrating with the celebratory government shutdown. So that's how this seems to go in recent years, but it'll get resolved as it always does at some point. But yeah, so every 5 years, the FAR Council by statute is directed to go through and take a look at many of the dollar thresholds that are in the FAR. And so those of you who've spent a little time cuddling up with the FAR and getting to know it, know that there are a lot of different thresholds for different things. If it's below this threshold, this dollar amount, you do X. If it's above, you do Y, and those sorts of things throughout the FAR. And those are just literal dollar numbers that are in there. And then the FAR Council every 5 years is tasked with going through, taking a look at what inflation has been like over the last 5 years, upwardly adjusting the thresholds in a manner that makes sense given the inflationary situation, as well as whatever other market-based type items that the FAR Council wants to consider in that making those adjustments. And so what you get is not like, hey, inflation has been X percent, and so we're literally just going to apply that to every dollar number. They usually end up being round dollar numbers. They'll say, hey, oh, this will impact X number of contractors or Y number of contractors, but what is it, the thresholds go up by some number every 5 years. And so that's what just happened. That was a proposed rule that came about last year when the FAR Council went through and actually did a lot of the math and said, here's what we're planning to do. Public, give us your feedback. The final rule just took effect October 1st to raise those thresholds. Let's talk about three of the ones that I think are biggest, especially from a small business perspective. We can mention a few others as well. So first, your micro purchase threshold. That's the threshold by which, it's not entirely true, but to oversimplify somewhat, all bets are off. That's where the government often can just use the government purchase card and buy stuff without worrying about a lot of the regulatory red tape. That's been at $10,000. That's going up to $15,000, and it's now up to $15,000.
That's a 50% increase.
It's a 50% increase. And so we know that inflation's been running hot, but I imagine a bigger increase than the general inflationary amount over that time. So $10,000 to $15,000. The FAR Council, as part of this process, gives some explanations. They're required by, there's actually a lot of statutes that go into regulation writing under the Administrative Procedure Act. Carroll knows this because we did a lengthy, was it like a 6-hour course on this subject for a group a couple times. Some of those regulations require the government to analyze the impact of these changes and how many folks would be affected by them. What the FAR Council came up with respect to this micro purchase threshold change is that it would be, they said, by a 9% increase in the number of acquisitions that are covered by the MPT. And so you've got a 50% increase, but they said it wouldn't actually be 50% more contracts that are being covered by the micro purchase threshold. It would be about 9% was their guess there. But it is still an important increase. The second big change is the simplified acquisition threshold. And simplified acquisition threshold is that threshold under which the government can use streamlined, simplified, efficient procedures, more efficient procedures to buy goods or services. The base simplified acquisition threshold, or SAT, has been for the last several years at $250,000. That's now up to $350,000, that base SAT. We don't use this term simplified acquisition threshold, but there's separate authorization to use simplified procedures for certain commercial products and commercial services. That's in FAR Part 13, 13.5, and that threshold has been at 7.5 million. That's going up to 9 million. And again, it's not the simplified acquisition threshold, but a special authorization to use simplified acquisition procedures for certain commercial items up to now to 9 million under that FAR 13.5 authority there. The last one I want to mention, and we can talk about a few of the others if you want to. There's a bunch of them, and some of them you're going to be like, I don't even know that was a thing in the FAR, because there's so many of these that are discussed in this FAR change, the final rule that came out. But the last one I want to mention ties back to where we talked about subcontracting plans and talked about how moving forward, other than small primes who are operating under subcontracting plans, according to now the new revised RFO, Revolutionary FAR Overhaul version of FAR 19, are going to have to find certified women-owned small businesses as opposed to certified or self-certified. But who has to adopt a small business subcontracting plan? You have to be other than small. You can't be a small business. So someone who exceeds the size standard that's associated with that acquisition, and the acquisition has to exceed $750,000 before you're required to do the extra work of putting together a subcontracting plan. Now that threshold is going up to $900,000. So there are going to be fewer acquisitions, at least a little bit fewer number of acquisitions. They're going to be subject to the threshold for other than small business to put together a small business subcontracting plan. On the construction side, that requirement has been 1.5 million, double the 750. That is now going up to 2 million. So construction only over 2 million would the prime that's not a small business have to do a subcontracting plan starting October 1st.
Yeah, just to recap, so we got a 50% increase on the micro purchase threshold, and then effectively it seems like it's about a 50% increase micro purchase in the 40% increase on the simplified acquisition threshold. But what's important about that is that between the 15,000 and the 350,000 is where by the FAR, which we were worried about they might take out, and could talk about that in the FAR overhaul might be a good segue into it. there was some discussion that the rule of two would go away within that specific threshold and within the set-asides. Could you talk about that rule of two and where it fits within both that simplified acquisition threshold between now the 15K to the 350K within that, and then also what about above that? I guess it would be good to talk about how does that operate within the micro purchase, because there's not really set asides in the micro purchase. So there's 3 different thresholds now for small businesses to take consideration into when they're looking at something within the dollar of an acquisition.
But yeah, first thing first, micro purchase threshold. Some small businesses will like that. They may have a relationship already just based on their business, and they know the government can plunk down that purchase card or whatever and buy from them. But there are no small business preferences below the MPT. They can buy from a large business too, and there's no small business preferences below that. Depending on your position as a small business, that increase may be good, bad, or doesn't matter. But I can't universally say that's a good thing for small business because you've actually increased by 50% the floor for what's called the rule of two. So the rule of two is really the foundational centerpiece. It's the foundational centerpiece of how the government prioritizes small business contracting. And I think really everything the government does other than that, which include ADA or SBA type programs and such, really flows in some part from the rule of two. And so the rule of two is a rule that essentially says that when it applies, and we'll talk about when it applies in a second, but when it applies, and I'm oversimplifying just a little bit, but when it applies, that if the contracting officer has a reasonable expectation of receiving 2 or more offers, this is based on market research, 2 or more offers from qualified, capable small businesses capable of doing the work at fair market prices, then the contracting officer either has to set aside that work for small businesses, do a small business set aside, or do something that's essentially a subspecies of small business award, such as an 8A set aside or sole source, such as woman-owned, etc. That's basically a summary of what the rule of two says. When does the rule of two apply? That's obviously a really key consideration and something we can talk about more with this revolutionary fire overhaul when we get to that. But there's 2 components of the rule of two as to when it applies. One is statute. Remember, statute is what Congress passes. House and Senate, bill on the Hill type thing, and the president typically signs that into law. Then there's regulation. And regulation is usually fleshes out the statute, makes it more applicable to folks, but it's written by unelected officials, and a regulation cannot conflict with the statute. The statute governs over a conflicting regulation. And so the regulation is just meant to give more life to statutes in many cases. And FAR is a regulation, Federal Acquisition Regulation. It's written by FAR counsel, unelected officials operating under statutory authority. So the statute says what Congress has written into law says that any acquisition between the micro purchase and simplified acquisition thresholds, the rule of two must apply. That's what the statute says. And so at a statutory level, this increase of the SAT from 250 to 350 is a big deal because this means that's a $100,000 increase in the universe of dollars by which statutorily are protected for small business competition under that rule of two. Once you factor that the floor went up by $5,000, it's a $95,000 change to the benefit of small businesses. However, the rule of two has long been under the FAR, has long been broader than just what the statute says, because the statute also says, hey, FAR Council, we want you to regulations that ensure that a fair proportion of federal prime contracting dollars go to small businesses. And what the FAR Council has done with that for many years, for decades, has said what works really well, that rule of two. And so even though the rule of two statutorily only must be applied between the MPT and SAT, we as a FAR Council think that's the best way to fulfill our mission of ensuring a fair proportion of contracting dollars above the SAT also go to small businesses. And so the FAR has long had a component saying that above the simplified acquisition threshold, yeah, the rule of two applies as well. And in the pre-RFO FAR, there were a slightly different terminology they used to define it. It was not quite as strict, but it was still applied above that threshold. So when we talk about the revolutionary fire overhaul process taking place, there was a lot of consternation and concern among the small business community that the rule of two above the simplified acquisition threshold would go away, because the FAR Council has absolute right to do that. And in fact, the executive order underpinning this RFO process said we want to bring the FAR back to its statutory roots. We want to eliminate most stuff in the FAR that's not statute required. required by statute, which the Rule 2 above the simplified acquisition threshold absolutely is not. It has been a fundamental piece of federal procurement policy for a long time, but it's only required by statute above that SAT. So where we end up here, and we can talk about the RFO in a minute, is a situation where these threshold increases aren't necessarily going to have a real life impact right now on which acquisitions are subject to the rule of 2, but it does put more acquisitions in that universe of being protected by statute from any future regulators who might just say, you know what, we're not cool with that rule of 2 above a certain threshold. They can remove it above the SAT, but without Congress cannot remove it between the MPT and the SAT.
Yeah, fascinating. So just to recap this segment on updates, I see this as a positive in one way. You've got an increase from 10,000 to 15,000 in the micro purchase threshold, which I talk to a lot of small businesses about. I think a lot of small businesses overlook the opportunity to participate there. And we know that those typically don't get posted to sam.gov. So the benefit of that is that if you're using a sales process that might have worked for you to reach out to your commercial clients, and if it's under that micro purchase threshold, if you use that same process to reach out and touch someone, you'll be able to potentially get a direct award. No competition is required, even though small business set-asides aren't required within the micro purchase world. Usually, if you could basically influence that demand, you don't even have to compete for it. So that's, I think, a big plus. And then on the other side, seeing the increase of the threshold for the simplified acquisition threshold. Yeah, so lose 5,000 there on one end, and then you gain on the other end. So I guess it's about a net gain of, if my math is right, $95,000 in new set-aside opportunity under the simplified acquisition threshold.
Yeah, that's about it. Yeah. So
Yeah.
that simplified acquisition threshold now, instead of ranging from 10 to 250, is between 15 and 350, which for a lot of small businesses, those are great contracts to go after. They're easier often to get involved in. Sometimes you'll find that some of the large businesses just aren't playing in those sandboxes. They're not interested in the smaller stuff. And so even if it's not being set aside, you just may not find as many large businesses that are as interested in it. So a lot of small businesses do really well, especially when they're starting out, but even after that, it's in getting a lot of these simplified acquisitions. And the idea is it's more streamlined and efficient from the government side, but also from the contractor side. There's less you should have to do in terms of paperwork to win and perform one of those. At least that's the idea. So it can definitely be a win for small businesses, especially those that are starting out or those that are saying, we're going to diversify from just going after some of the big $10-20 million contracts. Let's also get a portfolio of several simplified acquisitions going on at once too. That's another strategy that I've seen some contractors use.
Yeah, awesome. All right, shift to our last segment here, and this is a big one, which is the revolutionary FAR overhaul that's been underway, and we've been already referencing it quite a bit up to this point. But for those that might not be fully up to speed with exactly like what is this revolutionary FAR overhaul, can you give a little bit of a context on really what's happening here? And in particular, why have so many small businesses as well as small business advocates really been eager to look at what's being proposed now here in this FAR Part 19 overhaul?
Yeah, the revolutionary FAR overhaul process goes back to an executive order that was issued by the president in March. And what the president's executive order said was, we got this huge, crazy thing called the FAR. It's big, it's cumbersome, it's too much. We want to simplify it. We want to make it leaner, meaner, more efficient, work better for everybody, contracting officials and contractors alike, make it more readable, more user-friendly, or eliminate duplication, and, as I mentioned earlier, eliminate some things that are not actually required by the underlying statute. And so that was the genesis of this. Those who follow the ordinary process of amending the FAR know that it can take a long time to get something into the FAR. It took, after the SBA published a revision to limitations on subcontracting several years ago, it took the FAR Council 5 years to essentially copy that into the FAR. And it's not always the quickest process. However, this executive order said, we're going to overhaul the whole FAR. We're going to do it in about 6 months. We want you to do that in 6 months. We want it done by October. And they've pretty much gotten there at this point. And so it was a process that kicked off. As I said, it was a time crunchy type process to take a look at every single piece of the FAR, go through and find out which items are required by statute, which ones aren't, which stuff is too wordy, too burdensome, makes little sense, is repetitive, all these sorts of things. And so on a rolling basis, this revolutionary FAR overhaul process has been publishing revised versions of each part of the FAR. And the FAR comes in 52 main parts. And so it's a lot of work. And I don't envy the folks who have undoubtedly been spending nights and weekends getting this stuff done, but they've gotten it done. And they've not only published revised versions of the FAR, they've also published, in many cases, red lines that showed things they crossed out so you could more easily track what was done. They've published what they call practitioner album, which is intended primarily for government officials, but it can also be useful for contractors to get some commentary on how to actually use the FAR. They published, it's still a work in progress, this thing called the companion guide, does some of that same stuff. I would recommend that any contractor who's working with the FAR at least take a scan through those resources as well, the practitioner album and the companion guide, because they have some really useful information in there, and it's written as best as this stuff can be in plain English. And so that process has been moving along. It's important to know that this is not necessarily the final version of the revised parts of the FAR. How it's working is that these regulators are making these revisions to the FAR. They're asking procuring agencies to temporarily adopt these revised provisions under what's called a deviation process, which allows agencies to temporarily adopt something that has not yet gone through the formal rulemaking process. We talked about the Administrative Procedure Act when we started a little while ago, but ultimately each of these sections of the FAR have been developed by the RFO, Revolutionary FAR Overhaul, have to go through the Administrative Procedure Act rulemaking process, which means they're going to be proposed to the broader public as a final rule. The public's going to have the opportunity to comment. There may be further revisions to these rules based on public comment, and then they'll become finalized versions of the revised FAR. And so that will be an opportunity for small businesses and anyone else who's interested to have more input on what the final version of these rules look like. But in the meantime, we got to live with them, right? Because agencies are adopting them as deviations. They're in place on a temporary basis. FAR Part 19 is the part of the FAR that governs small business programs. And so as a small business advocate myself, former small business owner, someone who's worked with hundreds and hundreds of small businesses, it was probably the part of the FAR that I was most eager and a little bit nervous to see what was going to be done with it, because there are pieces that I knew when people said, no, they're going to wipe out woman-owned small business, they're going to wipe out 8A. I was like, no, that would be illegal. They're not going to do that. And they didn't. But there were other pieces where there were some concerns, particularly with respect to that rule of two that we talked about. Would the FAR eliminate the rule of two above the simplified acquisition threshold, which to me would have been an absolutely catastrophic event for small businesses? And when FAR Part 19 came out, which is late, very late September, right before the government said, we're out of here, peace, and shut down, that was the first thing I did, was like scroll down and see what happened to that rule of two.
Yeah, this is confusing because is it typical? Because you said that, okay, so there's been some changes that have been proposed, and we're only going to talk about RFO FAR Part 19 here today, by the way. But there's been changes that's been built into this. This has now been published. There's still a commentary period where people can make comments. It's not finalized, but the agencies are being asked to adopt these changes already. Is that normal?
Not to this extent. Deviations are definitely part of the FAR. They've never, to my knowledge, at least since I've been working in this world, been used to essentially deviate the entire FAR. It's usually one piece that we want to change before, because this APA, Administrative Procedure Act process, takes a while. You got to publish the proposed rule in the Federal Register. You got to accept public comment. You got to do all sorts of various other statutory items that are required to be done in connection with studying who's going to be impacted by this rule and all sorts of other things, which are intended to ensure that the public gets to comment, to ensure that the rulemaking is transparent, that it's fair, all these sorts of things. But deviations are intended to act more quickly. There's a need for a change, and we're going to do it temporarily. Think about it as where we are right now is, let's say that the CEO of an organization resigns and someone else is appointed as the interim CEO. That person has all the powers of the CEO, but they're not the CEO. They're just doing it on an interim basis, pending maybe being hired on a full-time basis. But being hired on a full-time basis is going to require a full-blown interview process by the board of directors and all this other stuff. And so that's where we are right now. Like, this is going to be the rule book for now, but it's an interim rule book. It's there until that we go through the full process to finalize it. The comment period period for this stuff is not open right now. It will be. Once it's published in the Federal Register, there'll be probably 60 days or so to comment on it. Like I said, I've never seen, and to my knowledge, has never happened, the deviation process be used for the entire FAR, which is where we are now. But that doesn't mean that it's not absolutely valid and in effect. And so that's where we are right now. So you should consider that these rules are in place, but they are still interim rules that could be changed before they're final in, who knows, a couple of years or something like that.
Yeah, so the takeaway is that the changes that we're about to talk about here are getting rolled in agency by agency. And so contractors may expect that they'll see some of these things happening in some agencies before maybe even others.
Yeah, absolutely. That's the other thing about the deviation process is that each agency has to say, yeah, we're adopting the deviation. They'll sign some memo, or their head of agency will sign off on doing a deviation. And so when you go to the Revolutionary Fire Overhaul site, for each revised part, there is a list of which agencies have adopted that part and what the date of adoption is, which can be very important because depending on when the revised part was adopted, it may or may not apply to a particular solicitation, a particular contract. And so, yeah, there can be some confusion. Are we operating under old FAR, or are we operating under RFO FAR? And it can depend on literally the date in which the agency in question adopted the revised version of that part. And so if you have a Part 19, let's say, and Agency X has adopted it and Agency Y has not, then Agency X is now operating under revised 19, Agency Y still is not.
Yeah.
And so we've seen that. And so you can go to the website and see who adopted it and when. I've done that to say GSA is adopting them the day they come out. They're busy writing them, and so if it's out, GSA has adopted it, but other agencies not necessarily.
It's so confusing, and I know that's why a lot of us talk about just keeping a focus on the fundamentals. Just keep doing what's good for your business in terms of just building value and competition, because honestly, it's probably for the normal contractors out there, you can't really know all of this stuff, but the best you can do is what you can control within your own framework, I think is the thing there. Yeah. Let's go ahead and jump into those changes, Stephen. The big changes that you've seen within that revolutionary FAR overhaul as it relates to FAR Part 19 in the small business section.
Yeah, just to piggyback on your comment there, I think that's right. Keep focusing on your business and your fundamentals. It's good to know this stuff at a high level. That's why we're having this discussion, know what's going on out there in the broader procurement world. But if I can barely keep it up with this stuff and I don't have a contracting business to run, there's a lot there. So don't be afraid to take advantage of experts who are out there. And that's not me trying to sell my services. I don't do that anymore. But there are folks out there who could help you. If you're like, I'm not sure which version of the FAR applies to this solicitation. Can somebody help me? There's somebody out there who can help you. So don't be afraid to take advantage of that stuff. Yeah, so first things first, and I didn't want to do spoilers, but the FAR Part 19, the big question when it came out for me that I immediately scrolled to was, what the heck happened to that rule of two? Because it was absolutely within the power of the revolutionary FAR overhaul drafters to eliminate the rule of two preference above the simplified acquisition threshold, which at the time was $250,000. Now it's $350,000. But anything over $350,000, of course, anything below the MPT, but that's not what was on the table. But anything above $350,000 could have been on the chopping block. And to me, like I said, that would have been absolutely catastrophic from a small business advocacy perspective, because so many of the dollars that are going to small businesses are generated by rule of two set-asides, or that the rule of two applies and the contracting officer says, you know what, instead of doing a small business set-aside, I'm going to do a woman-owned small business side. I'm going to do 8A sole source, whatever the case is. So that's the first thing I looked at. And that's a case of, I think, good news, but also bad news. And so the very good news is that the revolutionary FAR overhaul redraft of FAR Part 19 did not eliminate the rule of two above the simplified acquisition threshold. Could have done it. Probably one would argue that maybe someone in that room may have said we should do this because we're asked to withdraw the FAR largely to its statutory roots, and above the SAT is not a statutory root of the FAR. However, they came out, and this I think is due in part to some really strong advocacy that was done on behalf of small businesses by a lot of organizations out there. I'm not going to name them by name, but there was a lot of advocacy out there on behalf of retaining the rule of two above the simplified acquisition threshold and saying it's going to be catastrophic if you don't. And so the revolutionary FAR overhaul drafters said, yep, we get it. It's not in the statute above the SAT, but it's been on the books for a long time. It's fundamental to good procurement. That's essentially what they said. It's fundamental to good procurement to have this rule of two apply above the simplified acquisition threshold. So if contracting officers, regardless of whether it's above or below the SAT. If you've got an acquisition above the micro purchase threshold, you must apply the rule of two, just as you did before. In fact, maybe even a little bit more so, because the RFO eliminated the slight wording differences between the rule of two below the simplified acquisition threshold and above that existed in the previous version of the FAR. They just combined it all into one. So if it's above the MPT, rule of two, it's fundamental to good procurement. It's essential. We're keeping it. So that's great news. And to everybody who advocated for that result, thank you for your advocacy on my own personal behalf, and for those who were in that room, that revolutionary FAR overhaul process room, who came to that conclusion and said, nope, this is really fundamental. We're going to stick with the rule of two. Thank you for doing that. Again, this is just my personal opinion, but thank you for doing that. It's not completely good news, though, from the rule of two perspective, because there has been a very important question out there, which is, okay, we know the rule of two applies when you're awarding a contract, a new contract vehicle that is above the simplified acquisition threshold or below, and that continues. But what about an order? What about a task or delivery order under a multiple award contract, under a MAC? And the GSA schedule is its own universe, so we're not going to talk, and so that's always been outside this rubric. And so on the GSA schedule, the answer has always been the rule of two doesn't apply, but the GSA now has the ability, or the agencies now have the ability to do optional set-asides under the schedule. So forget about the schedule. But with respect to other MACs, other multiple award contracts in which there may be both large and small business holders of that contract, of that vehicle, there's been an outstanding question as to whether, when awarding or doing a competition for an order, the rule of two applies there. If we've got 100 awardees of a MAC and 25 are small businesses and 75 are large, and we as a contracting officer know that 10 of those small businesses are qualified, capable, likely to submit fair priced offers, we want to compete in order, do we have to limit it to those 25 small businesses, or can we open it to the full field? And what's happened is that the GAO and the Court of Federal Claims under the old FAR took different views. The GAO's view was that it was discretionary, that the contracting officer could do a set aside if he or she wanted, didn't have to. Court of Federal Claims had a different opinion, and a year or two ago in a decision called Tolliver said, no, it's mandatory, that if you have that situation, like I mentioned, where you've got two or more holders of the MAC that are qualified, capable, small businesses likely to submit at fair market prices, then you have to apply the rule two and do the order competition for just the small businesses. And the FAR didn't specifically say one way or the other. That was the thing, is that the GAO and the Court of Federal Claims reached different conclusions because the FAR was somewhat ambiguous on that point. And so the reasonable minds could disagree as to whether the rule of two was required at the order level or not. The RFO answers that question in the GAO's favor. The RFO version of FAR Part 19 says the application of the rule of two to orders under multiple award contracts is purely discretionary. It's purely discretionary. It's up to the contracting officer. There is no rule of two for orders. And so that essentially overturns the Court of Federal Claims case that held otherwise. And they can do that because they've changed the underlying rule. The Court of Federal Claims said, yeah, it's ambiguous what this rule says, but we're going to go back to this fundamental policy of supporting small businesses and say it applies to orders. But now the underlying rule has changed. Now the underlying rule says it's discretionary. And so that's the answer. And as Carroll, one of the other pushes we're seeing both in terms of the RFO outside of FAR Part 19, as well as just the priorities of the administration, is to push more work to best-in-class type vehicles, to multiple award vehicles. And that's all an efficiency thing. It reduces administrative burdens. I understand the reason for that. But as more work gets pushed to multiple award vehicles, that is more and more work that is now not subject to the rule of two. And any work that's being pushed to GSA schedule is already not subject to the rule of two. And so that's a loss for small businesses. That's a loss because you've got to win in that we preserve the status quo for the rule of two for standalone contracts, but we've got a loss in that we have now definitively answered the question, overturning a court decision as to whether the rule of two is applied at the order level. And the answer, according to the RFO, is no. And so that you come back with the good news, bad news situation from the rule of two part of the FAR Part 19 overhaul. And I've got one more item I'll mention on that, but I'm going to kick it back to you for a second because it's separate from rule two.
Yeah, so the rule of two is not required inside of the GSA schedules, for example.
Correct.
Are the contracting officers still able to do it if they want to?
Yeah, they can. So it's discretionary, and it would be under the is now under the revised FAR for other Macs as well. So they've essentially said, the RFO FAR folks essentially said other Macs are going to be treated like a GSA schedule has been treated for a number of years now, which is that small business set-asides are not required, but they're discretionary. And the contracting officer, if they want to, because they're supposed to meet these different goals, 23% for small businesses, 5% for women-owned, 5% for service disabled, and so on. If they want to do it, they can, but they don't have to. And so it's gone from the universe of, under the court case, mandatory set aside to discretionary set aside, not just for GSA schedule, but for all multiple award contracts.
A couple of more things, and I know we're already getting to our 90 minutes, and we still want to
get to talk about this.
We still want to get to the questions. There's a couple of more big things too, and I think as I was reading into this, there's some changes with regards to the order of priority in set-asides.
Yeah, and what the revolutionary FAR overhaul process has done, and there never was truly an order of priorities, not the way the VA has. And so if those of you are familiar with VA, know that VA has a very strict order of priority, and they go SDVOSB first, then VOSB, and then down the line to other small businesses. The old FAR Part 19 essentially said things like a contracting officer should consider a hub zone contract before they consider using a small business set aside. They should consider an 8A. Kind of these should consider language, but it's legally unenforceable. It was more just like a policy perspective, but should consider is no one can sue and say, I'm a hub zone, you didn't consider me. They'd be like, yeah, I thought about it and I didn't do it. But they took that language out. And so it was more from a policy perspective to take that language out and have small business set aside contracts be on the same level as 8A, hub zone, women owned, and SDVOSB, even just from a should we consider one before the other. And that's true now in FAR Part 19. It's not true for VA. This doesn't change the VAR, the VA Acquisition Regulation Supplement. Though that priority system is dictated by statute, and so that hasn't gone anywhere. So if you're a VA contractor, you're like, oh, good, I'm a small business set aside. Now I'm on the same level playing field as the SDVOSBs for VA. Nope, you're not. They have a unique system, but the FAR has now been normalized to say not only is a contracting officer before could you do a small business set aside even though you knew there were multiple hub zones, for example, that you just had to consider doing one and be like, nah, I'd rather have 10 small businesses bid than 2 hub zones, and that was good enough. Now you don't even have to do that. And there's one other area in which the FAR kind of overhaul equalizes programs a little bit is this once 8A always 8A rule, and that's the rule that it says that once work is put inside the 8A program, once is issued as an 8A set-aside or sole source contract, the follow-on contract ordinarily should remain in the 8A program unless there's various exceptions for that. It's new work because we added a bunch of new stuff or took stuff away or whatever. But generally speaking, what that has meant is that once, especially a services type contract is in the 8A program, then the follow-on contract stays there and it stays there and it stays there and stays there. The FAR overhaul says that work can be removed from the 8A program without going to SBA for consent, which sometimes contracting officers had to go to the SBA to get work removed, simply because the contracting officer wants to place that work with an SDVOSB set aside, with a woman-owned small business set aside, or with a hub zone set aside. And so it says, look, desire to compete the work in one of those other programs is good enough reason to take the work out of 8A, despite the once 8A, always 8A rule. And so I think that's good news for companies that hold those other certifications for sure. I think it's also good news for 8A companies who are going to graduate soon who have dual certifications, because a lot of times what happens is an 8A incumbent graduates, 9-year program term, they can't compete for the follow-on as the prime contractor because his work stays in the 8A program and the incumbent goes. And so an agency that likes the incumbent may say, you're both an SDVOSB and 8A, so we know you're graduated from 8A, so we want you to have a chance to compete for this work. We're going to put an SDVOSB, and the agency can do that now. I'm not sure that it's really a disadvantage to 8A, because people say, well, it means more work's going to come out of the 8A program. Yeah, I suppose so, but I wonder if more work is going to get added to the 8A program too, because contracting officers are not going to be worried that work gets stuck there in the same way that, so we'll see how that goes. But that's an important change that, again, this policy of quality among these programs.
But it also benefits the 8A graduates in a lot of ways, because before they couldn't, which was silly in a way, because it's like the idea is like you're building up this past performance and experience on a contract that you can't even compete for anymore in the future.
Yep. And I've worked with
So
so many folks who were in that exact situation. They graduated or they're graduating before that works for me bid, and they had to become a subcontractor to somebody else or try to be a joint venture partner to somebody else so they could still get a piece of it. But it's an awkward relationship because now you've got the incumbent as your sub, and you're supposed to be some other 8A in charge, but the incumbent's the one who really knows what they're doing. It's odd. And so it gives us successful incumbents who hold another certification. Keep in mind that this is only for woman-owned, hub zone, and SDVOSB. It's not to remove it to do a small business set aside. But if you hold one of those other certifications, then the agency could choose to remove it from 8A and compete it under the certification you hold. And that would give you the chance to retain that contract.
I think that might set up more opportunities also if you've got the WOSB, SDVOSB, or Hub Zone certification to have a relationship built. Maybe there's an 8A graduating that doesn't have any certifications outside of small business that they hold. So that might give an opportunity where it used to be in the past where that contractor would typically only be looking for another 8A firm that they could basically continue on with. They may be looking for partnerships that potentially now, if they have a good relationship with a WOSB or an SDVOSB firm, they could, I don't like to use the word lobby, but they could kind of lobby the contracting officers to say, hey, we've got this great team now. We've got this great partner that's a WOSB, and we'd love to potentially have a set aside under this new program.
Yeah, it just opens up all those sorts of opportunities. And I think that talking about successful incumbents, there's often a case where the government says, man, we'd love to give these guys a chance to compete for their own work. They've done such a good job, and we don't want to have to take a risk on somebody else unnecessarily. So that stuff can work. We'll see how this all plays out in practice, but I think it's an interesting change and one that sets up some these teaming and kind of strategic conversations that you just hit on there, Carroll.
Yeah, there's a lot more, and I would encourage you guys that if you really want to dive into more of what we talked about here, there's some places that you could go. One last thing before we actually end the show, and then we'll go to our Q&A, Stephen. And while you're talking about this, I'm gonna pull up a slide that I have for everyone, and I want to talk about it. I want to show the website because you mentioned there's going to be some opportunities for public comment under the rulemaking later, but there's currently still some opportunities for feedback. So I want to share my screen here, and I want to show this site. All right. So can you talk about that, Stephen, and what does this mean? Because there's the rulemaking and public comment, but then there's also this area on this site, and you could just Google Revolutionary FAR Overhaul Part 19. You'll probably find this link, but this is where the new rewrite is. And then there's a little link over there where you could submit your feedback. So talk about that feedback, and then also when might we see the feedback under the rulemaking process?
Yeah, so this is the kind of, we'll call it informal feedback. And I encourage folks to do this. And I know a number of small businesses did this with respect to the Rule of Two. This is your chance to just reach out to GSA, to the FAR Council, and say, hey, here's what I think ought to be in this rule. Here's problems that I have with what you've already published, et cetera, so that they can have that sort of informal feedback in the back. And so you can see there are areas that need refinement. I've seen a few of these. And that's not to knock anybody over at the RFO or at FAR Council. They've been doing a lot of work in a short period of time. There are bound to be areas that just, I'm like, it didn't make sense why they did it this way or that way. You can do that. You can say, I'm a small business and I please keep the Rule of Two, which a number did. Thank you for keeping the Rule 2, et cetera, et cetera. So this is, as they now have published the revised FAR overhaul kind of draft version 1, they are going back and making a few amendments, corrections to their own deviations. And we've seen a couple parts of the 2.0 part of the revised FAR. That's your comment, chance to influence maybe that process and say, we've read what you published in the deviation. Here's what I think you got. Here's what I think you got wrong. Here's what I think you should change. Here's what didn't make sense. Those sorts of things. This is not the formal rulemaking process. And so that's where they talk about the formal rulemaking process. That's going to be, and I don't know when that will happen. That will be, when you see that will be on federalregister.gov. The law says that to do a formal rulemaking process, and that's to take what's already been done here, these deviations, and turn them into permanent law. That's really what the effort will be. My guess is maybe next year that probably happens, but I don't know. It will be federalregister.gov, and that will be the formal process that's required by law to make permanent regulation. And that will open up a comment window that'll probably be 60 days, something like that, where you'll submit comments in a formal rulemaking setting to the agency, and the agency is tasked with responding to or considering all the comments that it receives that meet certain thresholds. If you're just like, I hate your rule, then they don't have to respond to that. But if you're like, hey, I think the rule should do X, Y, and Z because this, then they, in that setting, are required to think about that and respond to that sort of feedback. They're not required to respond to the informal feedback. And it sounds from the website, you're probably not going to get a response. But that doesn't mean they're not reading it. And I think it's a good practice here because they're trying to get, as far as I can tell, this stuff as buttoned up as they can before they go into that formal administrative rulemaking setting. And so if they can get the public feedback in an informal basis now, that lets them go in and refine what they've done and put a better product in front of the public when they go in for the formal process, which hopefully will narrow the time frame in which that goes from a proposed rule to a final rule. I imagine that's what they're thinking over there.
Yeah. Overall, it seems like OFPP in collaboration with the FAR Council has really done some good things in just terms of trying to reduce some red tape, make procurements a little bit more streamlined for the contracting officers, and even doing some things to preserve small business utilization and level the playing field.
Yeah, I think they're meeting what was asked of them. I think it's a difficult project. I think that what they've produced, that by and large, then obviously I'm going to have quibbles with it here and there, is it's more readable, it's more usable than the old FAR, which is important, and hopefully will lead to more efficiency in terms of procurement and more understanding of the rules, not just through the FAR itself, but through resources like the Practitioner Album and the Companion Guide that will help contracting officials and contractors alike understand what the rules are. Now, that said, there are definitely things that I'd be like, did you have to wipe out the rule of two for orders? As a small business guy, I don't like that. Now, if somebody else would say, no, we do enough for rule of two as it is. That's just a policy disagreement that folks can have. And so I can say I'm glad they did the rule of two for standalone contracts. I'm not glad they got rid of the court decision for orders, but that's a personal policy viewpoint that I have. In terms of getting to a more usable product, whether you agree with the policy outcomes or not, and I agree with some and not with others, obviously, I think they've largely answered the call and are going to continue to refine this product so that we have at least a more understandable, readable rule book, which benefits everybody in the procurement community.
Yeah. You know what? Maybe we'll see some changes to that even after the more comments go in. So that's why we encourage you guys to go and make your comments here and make your case for it. And in fact, a lot of the agencies can maybe even look to the way that the VA has operated, because even though they have a rule of two still in place, but we won't go into that, but that's because of a statutory authority. So anyway, people can study how that's worked at the VA, and maybe in the future we can come back to that. But yeah, overall, you can't really make changes, I think, especially with all the different socioeconomic groups that operate within the federal acquisition environment. If you change one thing, it's going to impact another thing, right? And what might be positive for one might be not for another.
Yeah, absolutely. And like some of the stuff is just policy perspectives and outcomes. And I wear my bias on my sleeve. I'm a former small business owner. I represent primarily small businesses. Those are my people. That's my group. Yeah. I'm not shy about saying that, but I also understand that not every battle is going to be won on behalf of small businesses, that there are other perspectives too. And the contracting officers might want to open the competition to all 100 on that vehicle as opposed to 25 because they think they're going to get better pricing, better solutions, more competition. I get that. So those are just policy decisions that have to be made, and some go the way I might want and some don't. I get that. But in terms of, like I said, putting together something that is more usable by the procurement community, I think they're definitely on the right track and seem to be working still to refine that so that it's even more usable, which has been something that's long time been needed in this environment.
All right. I just want to say thank you guys that are watching us streaming. If you actually want to join us in our Q&A and you're just watching on YouTube right now, streaming live, you could go to Vology.com/roundup, register, and come into the Q&A session. We still have some room here if you want to join us. Overall, I think, again, we go back to the fundamentals. If you guys just focus on your fundamentals, continuing to build up your value and really be a great contractor. And also, unless we change the topic for next month, we're planning on talking about leveraging AI. I think that this is going to be a big opportunity where small businesses can get a lot of advantages, more than what even the set-asides could produce potentially. And all this is, we'll see in time how this all shakes out and what is the effect on the small business world, on one group or another group. And so time will tell. But Stephen, thank you so much. This was a great session. We covered a lot of ground here. We couldn't get to it all, but we're going to continue talking about this. And so I encourage you guys to continue joining us once a month. And again, we'll have the new link for the registration on our next month episode of GovCon Roundup Live, again at govology.com/roundup. We'll see you on the next one.
Thank you, everybody, for joining us.
Yes, thank you, Stephen.